The court knows the United States Supreme Court has long acknowledged that the First Amendment protects the rights of the public. Federal narcotics charges against, among others, John DeLorean, and the Brooklier case involved a RICO prosecution against members of the criminal enterprise La Cosa Nostra.
Like you, be strong to hold the powers of the sun.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host Pavarotti, and I'm here to bring you some exciting news about the Idaho 4 case. Now, yesterday, I didn't even realize it until later last night, they called a special hearing to hear those interested parties, which in this case was finally the media putting their stamp down on the case and trying to get things open to the public because they know at this point, just like everybody else, they're not sure of the travesty, but they know that there's a travesty happening and they want this stuff out there just like you and I do. And they're stepping in court to try to get it done. You see, in America, we have this thing called freedom of speech, but we also have this thing called freedom of the press. And you see, freedom of the press is there to protect the freedom of speech. So they're fighting hard. Now they're fighting back. They're pushing back, but that's okay. Very good hearing, and there is some huge takeaways from it, and I'm about to show them to you. Let's get right into it.
In addition to ensuring that the judge and the prosecutor carry out their duties responsibly, but as I understand the non-dissemination order, Your Honor, and its purpose, it's directed at comments or statements that are made outside of court proceedings and pleadings, and not at what can be said by the parties or their counsel in the courtroom. And the very purpose of the non-dissemination order, as I understand it, Your Honor, was to prohibit those sorts of extrajudicial comments by people who would be in the know, but that in-court proceedings are precisely the kind of information that should be available to the public as this case moves forward.
Excellent argument there by the media. And this is a group of about 18 different media outlets that have come together as interested parties to try to get the information available in this case. Now, why are they doing that? Real simple. Because they believe constitutional rights have possibly been trampled on in this case. Now, that's a double-edged sword, in my opinion, because their interest is because of the possible constitutional rights violation due to the unethical or illegal use of the IGG investigation in this case. However, only common sense at the end of this will tell you this has nothing to do with a constitutional violation and use of the IGG. As I'm going to show you by the end of this, this is a whole nother ball game. This has to do with lies and manipulation of evidence by the state in this case, not unconstitutional uses of IGG. Watch and see.
The evidence, whether the evidence that the state seeks to introduce at trial was gathered in a method that is constitutional or meets evidentiary thresholds for admission. A motion to suppress may be the critical stage of a criminal case. If essential evidence is suppressed, then the government will not be able to meet its burden of proof at trial. Indeed, Mr. Kohbeger made that exact argument in his filing yesterday. The purpose of the IGG was to investigate a criminal case. What is more, without IGG, this case would never have been brought against Mr. Kohbeger. The public should know precisely what law enforcement and prosecutors did in gathering such evidence and why and how the defendant thinks that was illegal.
You see, like most people out there, the press believes that this was an unconstitutional use of the IGG in apprehending Mr. Kohbeger. What they're going to find, and it looks to me like Judge Hippler now knows, is not only was it unconstitutional use of investigative techniques with the IGG, it was a sham. It was a false flag sham of an investigation manipulating IGG. And I think the judge has figured that out, and he's going to let the cat out of the bag here in just a second.
To know whether a law enforcement officer swearing that they have told the truth on issues as critical as these, whether evidence was gathered properly, and whether law enforcement made deliberate or reckless false statements to a court in gathering evidence, there is significant public interest, and public access plays a significant positive role in the functioning of the particular process as the court outlined in the earlier cases I've identified. It's particularly true here, I think, Your Honor, with the Franks hearing, where there is that question regarding the truthfulness of the officer involved. In any criminal case, I would submit that it's of extreme public interest to know whether a law enforcement officer swearing that they have told the truth in a filing with a judge that will be used to gather evidence that can significantly impact the life and liberty of an accused, whether that law enforcement officer did in fact tell the truth or whether the officer made deliberate or reckless false statements. I think it would be different, Your Honor, if it were a private citizen who made a misstatement of facts and there was a hearing about perhaps that person. The calculus might be a little bit different, but this is a person, a law enforcement officer who is cloaked with authority and has the ability to seek process, to get evidence, and ultimately lead to charges against an individual.
Now, for those of you watching around the world, it's very important to understand what's going on right here, because I'm telling you, this is what makes America and our Constitution different than any other country around the world. You see, with free speech and freedom of the press, those are both rights, and they're rights designed to right wrongs, okay? In this case, we know that there's wrongs. Well, there's a process to righting those wrongs. When they try to hide everything, then the press steps in and they apply pressure. Now, that pressure is not immediately upheld. Okay, they don't come in and apply pressure and then bam, everything's just right out in the open. No, that is the start of the process. They apply pressure, and then the pressure begins to mount on our state and federal agencies. And once that pressure starts to have impact. Now, they're always going to try to cover their butt. You're going to see here in a minute that the judge is going to do his best to cover some butts, but he knows that he can't. So he's going to make statements, I think inadvertently, that's letting us know what's going to take place, because I believe he's already made his decisions on some things. But he's going to try to cover some butts, but he's also going to start feeling the pressure and letting us know that this stuff may stay under wraps for now, but eventually everything's coming out. And he's also letting us know that there's some things that are about to happen in this case that are huge. Pay close attention.
The defense wish to add anything based on Ms. Olson's argument that was not previously presented?
I would like to make the record on behalf of the defense.
Beyond what you did yesterday?
It would be consistent with what I did yesterday.
Okay, but I heard what you did yesterday. So do you have anything new to add?
I don't have new information to add, Judge, other than having the ability to talk with the team about what your suggestion was and our concerns about arguing in open court. Would you like me to just address that?
I'm not sure what you're referring to, so I apologize.
So we had discussed that the evidentiary hearing portion of it for the IGG would be closed.
Correct.
But that we would argue the legal arguments in open court if we did not talk about the evidence that was brought out in the closed hearing. And after thinking about it overnight and talking about it today, we do not think that we can parse the argument that way. So it's still our position that all of this should be held publicly, openly in court. And that's our same position with the Franks.
Part of the rationale presented to the court yesterday for opening it was in order for the defense to make their case to the public. That's exactly why it's not open.
Okay, so you heard that, right? You gotta love Massoth and Taylor. May even love Logsdon before it's over with. But what did we just learn right there? And yesterday, in the day before closed hearing, the defense was fighting to get everything available to the public. Everything. What did the judge say? That's his way of trying to shut it down and protect. He says, yesterday your argument was you want to make your case to the public. And that's exactly why we can't do that. You see, folks, this is where you got to put your thinking caps on, okay? Would the defense of Bryan Kohbeger want to make their entire case to the public and show unequivocally with all of the evidence that is trying to be suppressed, including the IGG, that if that evidence truly led to Bryan Kohbeger, the IGG identified him, the buccal swab matched him, all of the evidence that they have, they want it out to the public. They want to make their case to the public. If that evidence actually led to Bryan Kohbeger and they were trying to get him off on unconstitutional searches, which means they're trying to get him off on technicalities, would they really want the public to know that? Would they really want to get Bryan Kohbeger off of a quadruple unaliving just so that he could walk out in the street and get lynched by citizens? Think about it. They're trying to make their case to the public and have everything open to the public because they have found real evidence that law enforcement manipulated the IGG, lied on the affidavits for search warrants, and the evidence that they're getting suppressed is actually evidence that proves Bryan Kohbeger is innocent in this case. Now, Hippler's got to fire back. He's got to try to protect the state. But you're going to see that his protection of the state is weakening simply by this proceeding.
I am, as I told the parties yesterday, particularly sensitive about closing things when we don't need to. And I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and to provide better rationales as to why I should seal what they're asking me to seal. That said, with respect to in particular, the IGG issues, particularly where I don't exactly know what the evidence will be forthcoming, the potential impact on a jury pool in this case. This case was moved to this court because of the defense's assertion that they could not get a jury pool in northern Idaho that would be unaffected by the case, even with the non-dissemination order in place. I appreciate the defense has shifted its position to a degree here. I'm concerned that the purpose of the shift is to try the case publicly as was offered to me.
Try the case publicly as was offered to him by the defense.
And in particular exposed to evidence that ultimately may not come into this trial. I think there is need to be careful when we are addressing evidence that potentially is not going to be evidence in the case, which is the concern that I have in particular with the Frank's hearing, as that does appear to be evidence that may not come in, and it may not be evidence that has been particularly disseminated to date. Relates to some of the motions to suppress that doesn't need to be discuss specifically. For example, the evidence produced by the warrants they seek to strike. In particular, the evidence with respect to the IGG, I think at this point it's appropriate to keep that out of the public domain for the time being. Now, that may change down the line. My order certainly on the issue will ultimately give some information so that people can follow what happened from a legal perspective. But some of the factual details, until I know what those are, and I've seen that, I can't make that determination better. And so I think that this is the best way to proceed, because I can't unring a bell once it is rung with respect to potential evidence that in particular may not be evidence in this case. At the end of the day, regardless of the outcome, the likelihood is everything will be unsealed. And before then, as soon as it can be done in a way that protects the case and the jury pool, which is the parties' rights, both parties' rights to a fair trial is paramount, as is the public's right to know. But I also have to weigh that against the ability to have a fair trial by getting a jury panel that has not been tainted by the publication of widespread publication of evidence that may not be admissible at trial.
Okay, folks, so there's a lot to unpack there. And I took that long hearing and I cut it up for you and get you the most critical parts. So the things to unpack: number one, the defense is now wanting everything out into the open. They want a public trial because they know that their client is innocent, not because they want to get him off on a technicality. The second thing is, you can see throughout that hearing how the judge has started to soften already. He's telling the parties, I'm tired of sealing everything. Give me good reasons to seal things going forward. I want this stuff to be out there into the public, but I need to hear the evidence first, because I don't want the public hearing all of the evidence, especially the evidence that's likely to be suppressed when they go to seat the jury pool. So he's already letting us know there is evidence that he is likely going to suppress. And he let the cat out of the bag as it relates to the Franks motion. That is going to be heard, and he's already made his ruling on it. He told us, listen close.
Which is the concern that I have in particular with the Franks hearing, as that does appear to be evidence that may not come in, and it may not be evidence that has been particularly disseminated to date, as that does appear to be evidence that may not come in, as that does appear to be evidence that may not come in, and it may not be evidence that has been particularly disseminated to date, and it may not be evidence that has been particularly disseminated to date.
The Franks evidence, that appears to be evidence that may not come in. That appears to be evidence that may not come in. You don't have to be Sigmund Freud to understand that there is something big in the Franks, and he knows that that's evidence that may not come in. No, he knows that's evidence that's not going to come in. And the second part to that was, and it's information that hasn't been disseminated to this date. What does that mean? That's information that's not out there in the public to this date, hadn't been disseminated. What's in the Franks motion that hadn't been disseminated? Is it the fact that they have uncovered the confidential informant? We shall see. But there, it is clear from the way that Judge Hippler is talking about this, there is many things tomorrow or today in the hearing and tomorrow that is likely going to be suppressed in this case. And with that suppression, does it equal a dismissal? We're going to find out quick. But if this case is dismissed, we've got to keep the fight going to get the real truth out there and the proper people the proper people under arrest and on trial for this atrocity in the public. So it's time to really hit hard on what's really going on in this case. It has nothing to do with Jack D and the frat boys, I assure you. And I've got a video that I'm going to go ahead and release today, and it's part 1 of a 5-part. And we're going to get the information out there for everybody to understand the truth in the Idaho 4 case. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. Until next time, Pavarotti's out.